The California Tenant Protection Act has major changes coming in 2024. In the big stack o' bills that Newsom signed in October of 2023 was one known as SB 567, and this is making changes to the California Tenant Protection Act that start April 1st, 2024. In this quick guide for renters and landlords, we are going to run through SB 567. Hey there! Christian Walsh, real estate agent with Wire Associates. We've been helping tenants and landlords understand their rights before things go wrong. And remember, we can't give tax or legal advice, but for the most honest and up-to-date real estate advice, subscribe to this channel. The California Tenant Protection Act is statewide legislation covering rental properties throughout the state of California. There may be local county or city ordinances that have more strict procedures that must be followed. So make sure you understand whether there is a local ordinance that must be followed for a particular property instead. Let's dive into the differences. Now that SB 567 is coming, how is this going to change AB 1482? How will this change the California Tenant Protection Act? We're going to run through quickly. I'm going to have more content coming, don't worry. So it is broken down into before April 1st, 2024, and then after April 1st. So all of the changes under SB 567 are going to go into effect after April 1st. So April 1st, 2024 and beyond. So very first thing, exemptions, actually nothing changes. That is going to stay the same. So we've done other content. You can dive in and listen to that. But essentially it boils down to single family condos, townhomes, owner occupied duplex, any buildings that are younger than 15 years old. Any one of those things potentially would make that property exempt from AB 1482, exempt from the Tenant Protection Act, as long as the landlord gives the exemption language. And we've done other content on that as well. So there isn't a change there. That will stay the same. So no additional properties are going to fall under the Tenant Protection Act. The changes will come, though, for the properties that do fall under the Tenant Protection Act. So two of the major changes are made to what happens under the no-fault terminations of tenancy. We'll start off with owner move-in or family move-in. Remember, it's a straight line. It could be an owner. It could be a spouse. It could be a domestic partner of the owner. It could be a grandfather, father, child, grandchild. So niece, nephew, that doesn't apply. Brother, sister, that doesn't apply. So under the old rules, it was 1 month relocation assistance plus proper notice. The lease needed to have certain language in there depending on when the tenant entered into the lease. Now under SB 567, there is going to be again 1 month's relocation assistance. There's going to be new language that goes into the notice, and that person must have 12 months of consecutive occupancy in order for that to qualify as owner move-in. And here's the language of the law right here. We recommend that you actually check it out yourself. We have a link below so you can take a look. This is specifically related to owner move-in. Talks about some of the things that we just discussed. In addition, mentions the fact that if the landlord moves family in and they don't stay for 12 consecutive months or don't move in within 90 days, that the landlord has to offer the property back to the tenant who was asked to move out at the same price and terms. And it also further outlines what an owner means, what the intended occupant means. Definitely have fine-tuned the law because some folks have been attempting to skirt the law and get creative with owner move-in. This is an attempt to wrangle that in. Also important, the notice has to mention the names of who's moving in and the relationship to the owner. And the tenant is able to request proof that the intended occupant who's moving in is related to the owner. So that's another big change. Another big change comes under the category of no-fault termination of tenancy for remodel or demolishing the property. Used to be 1 month relocation assistance and proper notice, 30, 60, 90-day notice. Now, in order to take advantage of this termination, you're going to have the permits ahead of time for the remodel or the demolition. You're still going to owe the 1 month's relocation assistance. The the notice is going to have new language, and we'll run through that quickly. If you're learning something from this video, of course, hit that like button and subscribe to our weekly email newsletter. It's completely free, and you'll get updates like these delivered gently to your email inbox. And some language in the law related to the substantial remodel or demolition. It must include the following statement now on the notice itself. There needs to be a description of the remodel, how long it'll take, and when the demolition is expected to be finished if it's being demolished. And then it must include copies of the permits. If there aren't permits for whatever reason and they're doing an abatement, for example, it would needs to include the contract with that abatement company. And then if the tenant's interested in reoccupying the property after it's done, they have to let the landlord know. The law does not require that the tenant pay the same rate and terms be matched in the event that the unit is substantially remodeled. But if the landlord doesn't do the substantial remodel or doesn't do the demolition, the tenant can move back in under the same price and terms as when they were asked to move out. One other major change under SB 567 is now the Tenant Protection Act has some teeth in the event that the landlord does something wrong. So in the past, there wasn't much a tenant could do. So for example, landlord said they were going to do a substantial remodel, moved out, and the landlord didn't do the substantial remodel, put it back on the market. Now a tenant is going to be able to go ahead and take advantage of civil action to collect damages. And what are those teeth? What are those penalties? Well, they're actual damages, the reasonable attorney fees and costs, and if the landlord or owner has acted willfully or in malice, it can be up to 3 times the actual damages. Plus, there could be punitive damages. So there's a lot of teeth now to the new Tenant Protection Act. California is a complicated place to buy or sell real estate. Don't even think about doing it without reaching out to us first. All right, you made it to the end. It wasn't that painful, was it? So here's some advice before this legislation takes effect. In particular for landlords, you are going to want to make sure, landlords, that if your property is exempt, that you've given the appropriate exemption language to any current tenants. Now, we've released another video where you may have missed your chance to deliver the exemption notice, so make sure you check that out. Any new tenants that are coming into your rental, make sure they get the exemption notice if the property is exempt. Because if a landlord does not deliver it with the lease now, that exemption may not take effect. And renters, make sure you know what you're signing and make sure the property truly is exempt if you're signing the exemption language. The other big piece of advice for landlords is to reach out to an attorney before issuing a notice to terminate tenancy. As you can see, landlords, it's getting more and more complicated to be a landlord and terminate a tenancy. You have to make sure that you've reached out to the appropriate professional and followed the appropriate steps, because it could invalidate the notice or it could leave you open to an action for damages. And of course, renters, make sure you understand what your rights are related to your tenancy and the termination. Leave your AB 1482 and SB 567 questions below. I'm sure you're going to have some. And if you like this video, you're going to love this next one. Thanks for tuning in. This has been Christian Walsh, real estate agent with Wire Associates, Berkshire Hathaway Home Services, and we can't wait to hear from you.